All right. Well, let's get this started, and then folks will continue to trickle in, no doubt, over the course of the next hour. We will welcome them when we do. Hello, everyone. On behalf of the San Francisco Law Library, welcome to today's program. Let's talk about the Supreme Court. My name is Ben Feuer. I'm the moderator of today's program. I'm also the chairman of a law firm called the California Appellate Law Group, which is a nearly 20-lawyer boutique law firm that handles appeals in California, the federal circuit courts, and the U.S. Supreme Court. If you have any comments or questions about today's program, you can certainly email me. You can find my email and other background information at www.calapplaw.com/Ben. We have a really terrific panel with us today, and I'd like to introduce them to you. First up, going alphabetically, we have Erwin Chemerinsky. Erwin is the Dean of Berkeley Law and the Jesse H. Choper Distinguished Professor of Law. He comes to Berkeley after a number of other very impressive appointments. He was the founding dean at UC Irvine and a professor of First Amendment law there. Before that, he taught at Duke, and before that at USC, and before that at DePaul in Chicago. So he's been all over, but I think the weather here in California has finally won him over. Dean Chemerinsky is the author of some 14 books, although they may be good, they seem to be going up by the week, including leading case books and treatises on constitutional law, criminal procedure, and federal jurisdiction. He was unsurprisingly incredibly productive during the pandemic, writing 2 more books, one on how the Supreme Court has empowered the police and subverted civil rights, and another on the religion clauses and the case, making a case for separating church and state. He's also the author of well over 200 law review articles, and he seems to have an op-ed every week in a major American newspaper. Every once in a while, he argues in the US Supreme Court. He's a fellow of the American Academy of Arts and Sciences. In 2017, National Jurist magazine named him for the second time as the most influential person in legal education in the United States. And this past January, he was named president-elect of the Association of American Law Schools. He graduated from Northwestern, my own alma mater, and from Harvard Law. Next up, we have Sarah Harris. Possibly the only thing Erwin did not do in his illustrious career is clerk on the US Supreme Court, but fortunately, Sarah Harris did. She clerked for Justice Clarence Thomas from 2015 to 2016, and before him, 2 appellate judges, Lawrence Silberman on the DC Circuit and Sandra Lynch on the First Circuit. She served in the Office of Legal Counsel, I believe, between her clerkships. That's one of the most powerful, little-known offices in government. It essentially provides interpretations of federal law for the executive branch. She then went into private practice and today handles Supreme Court and appellate work as a partner at Williams & Connolly in Washington, D.C. She has argued twice before the Supreme Court. She graduated summa cum laude from Princeton, which is truly incredible, and merely magna cum laude from Harvard, where she was clearly slacking. Between the two, she got a master's and a PhD from Cambridge. Next up is David Latt. David is one of the most influential people in the entire field of law, something I've been telling him for years, though I'm not sure he believes me. David brought transparency and accountability to the business of law, especially the Tony world of large billion-dollar law firms, as the founder and longtime managing editor of the blog Above the Law. He did that until 2014 when he left to write a novel called Supreme Ambitions. Before Above the Law, David brought vibrancy to the seemingly monochromatic federal judiciary as the pseudonymous author of the blog Underneath Their Robes, where he reported on judicial gossip and Supreme Court clerkship hires. His day job at the time was an assistant U.S. attorney under Chris Christie in New Jersey, who has obviously gone on to other things. Before then, David was an associate at Wachtell Lipton, Rosen and Katz in New York, and a law clerk on the Ninth Circuit to Diarmuid O'Scanlan. Before that, he graduated from Yale and Harvard Law. Today, David has a Substack, which is like a newsletter. It's called Original Jurisdiction, and you can find it at davidlatt.substack.com. And finally, our only non-Harvard Law graduate on the panel, Fred Smith, went to Harvard undergrad, but then Stanford Law. So he also understands the value of good weather. He is also now a professor at Emory, where they also have pretty good weather. Fred, too, clerked on the U.S. Supreme Court for Sonia Sotomayor, and before then for Barrington Parker on the Second Circuit and Myron Thompson on the Middle District of Alabama. That's Montgomery, Alabama, the real South. Fred is a tremendously prolific legal writer, also publishing in the law reviews at Columbia, Harvard, NYU, Michigan, Stanford, and others. He also does a great deal of international legal speaking work, especially in countries struggling with the rule of law, though I suppose we haven't been necessarily doing so hot on that count ourselves. Fred also focuses a good deal of his time on social justice issues. He's heavily involved in community development in Atlanta, where he lives. He serves on the board of the city's official development authority, as well as the Atlanta Mayor's LGBTQ Advisory Board. So we are really thrilled to have Fred, David, Sarah, and Erwin here with us today. Really, there are not too many upshots to the pandemic, but the development of video conference CLEs that lets us bring folks in from around the country rather than just in the Bay Area is one of them. It also gives us the ability to do programs like this for free through the San Francisco Law Library. It's a free library, and it always gave free public programs to the public in their conference room before the pandemic, but that room could hold about 35 people. And today, I think we had something like 325 people registered. So to the extent there's any silver lining to the last few difficult years, we'll take it. So let's turn to today's program, where we have a lot to cover. This is a broad discussion about the U.S. Supreme Court. We're going to discuss some cases and some doctrines. We're also going to try to take a step back and look at the trends that we see shaping the court. We're going to talk about the development of the doctrines. We're going to talk about the composition of the court, the role some of the justices are now playing, the impact of our moment in history, how the court is reacting to that, and if we have time, a few of the other forces at work on the court today. I'm also going to try to leave time for questions at the end. It might go past the hour mark to do so, but if hopefully our panelists can remain a little bit and answer some, you'll be able to ask your questions in the chat window. So if you type them into the chat window, I'll do my best to look at them at the end. And then I hope the chat window is active. I think it is. And then I'll do my best to look at them at the end and then ask them to our panelists. So without further delay, I do want to start today's program off by talking about some of the doctrines, especially the really controversial doctrines before the court, not just in the specific cases in this term, but where those doctrines seem to be heading and have been heading over the last few years and the years to come. With our now newly firmly conservative Supreme Court. And the doctrine that I want to lead off talking about is one, we did not plan this program to come a day after the very contentious abortion arguments in the Supreme Court yesterday, but it happened to be that way. And the doctrine we want to lead off talking about is abortion. I want to, start with Erwin to talk about that. So Erwin, there really is almost no issue more controversial in the United States than abortion. It's the centerpiece of confirmation to the Supreme Court. It was the centerpiece of a huge amount of support for President Donald Trump. What's going on with the abortion right after yesterday's argument and going forward?
Thank you. It's such a pleasure to be part of this great panel. I think you have to realize that the current court is the culmination of a half-century effort by conservatives to create a staunch conservative majority on the court. They succeeded. Between 1960 and 2020, we had 32 years with a Republican president and 28 years with a Democratic president. But during this time, Republican presidents got to pick 15 Supreme Court justices, and Democratic presidents got to pick only 8. And above all, especially in recent years, Republican presidents wanted to pick justices committed to overruling Roe versus Wade. As everyone knows, yesterday, the Supreme Court heard oral argument in Dobbs versus Jackson Women's Health Organization, and involves a Mississippi law that prohibits abortions after the 15th week of pregnancy. Under Roe versus Wade and Planned Parenthood versus Casey, states cannot prohibit abortions before viability, which is about the 24th week of pregnancy. So if the Supreme Court follows precedent, the Mississippi law is clearly unconstitutional. But after reading the transcript, after listening to the oral arguments yesterday, it's clear to me that there's 6 justices on the court to uphold the Mississippi law. I cannot count to 5 just to strike it down. I think the only question is, how will they do it? One possibility is they could uphold the Mississippi law, but not express views on laws that prohibit abortions before the 15th week of pregnancy. Or they could simply overrule Roe versus Wade entirely. Prior to the oral argument, I thought the former was more likely, that they were going to uphold the Mississippi law, but not express any views on whether they were overruling Roe versus Wade entirely. After the oral argument, my prediction is it's going to be 6-3 to overrule Roe versus Wade. We can talk about the implications of that. We can talk about the implications in terms of women's lives. The reality is about half the states will have laws that prohibit all or virtually all abortions. Women in those states with money will travel to states where abortion is legal. But women who don't have money, teenagers, will again face the cruel choice between an unwanted child and an unsafe back alley abortion. We can talk about the effects on the political process. I think abortion will come to dominate our political process like never before, because state legislatures and city councils can prohibit abortion. In fact, I predict the next time there's a Republican president, Republican Congress, there'll be an effort to adopt a national law prohibiting all abortions. In many states, 39 to be exact, there's some form of elected judges. There'll be pressure on state courts to use state constitution to protect reproductive freedom. So in every state judicial election, abortion will be a major issue. It is going to be a seismic change in our political system and an enormous one for women's lives.
Okay, that's heavy, and I think everyone needs to get ready for it. The 21st century really has begun. Let's talk about another doctrine. Let's talk about religion. Let's talk about the doctrine and laws on free exercise of religion and the establishment of religion. Let's turn to Sarah Harris to tell us a little bit about how she sees religion and the laws about religion developing in this Supreme Court.
I feel like this is one of the most interesting areas of the court's docket, because if you went to law school, I think between like 1960 and the mid 2000s, your view of what the law may have always been is probably 2 things. One is that states, the government should, as a general matter, cannot support religious exercise. It really has to sort of stay pretty far away from intervening in that way. And 2 is that neutral laws that incidentally might have an effect on religious exercise are probably fine. And so I think you can think of it broadly, especially from the 1960s onwards. The court that was really the zenith of an era where the court, I think, was very skeptical of the government in any way seeming to promote religion, and indeed sort of feeling, I think, a permissible sense of keeping religion to the side and perhaps treating religious groups not as favorably as other groups, excluding them from general benefits. The tide has significantly turned, not just sort of in the last couple of years. I would say this is like a 15-year development, but really accelerating now. And I think 2 things are going on. So for the Establishment Clause, I think there really has been a reconsideration of something which you may know of called the Lemon Test, which was the traditional test for Establishment Clause violations. It's a widely derided 3-part test because it was sort of a little fuzzy in how to apply it, but you look at whether there is a secular purpose, secular effect, and risk of entangling church and state. And these days, the Lemon Test, there's all sorts of metaphors the courts have, the Supreme Court has used to describe the fate of the Lemon Test. I think it's essentially fallen by the wayside. The court in a 2019 decision essentially said they don't think the Lemon Test governs anymore. They're not really sure or willing to agree on what comes next. But I think going forward for the Establishment Clause, there is a much greater sense that things like, for instance, a 40-foot cross on public land, which was an issue in the American Legion case in 2019, is perfectly fine. And the test really is going to be, are these displays things that are historically have been part of American history? That's really the test, I think, going forward. On the free exercise front, similarly, a lot of action on the docket in particular in recent years in the Supreme Court. It is a keen area of interest for a lot of the justices. And for Justice Alito in particular, I feel like this is sort of his signature issue. He is clearly very, very interested in the history of free exercise and just, I think, passionately engaged in it. The biggest development, I think, is questions about the future of a case called Employment Division versus Smith. So that is a case that says that generally applicable laws that incidentally burden religion are generally permissible. The court had a chance to overturn that case last year in a case called Fulton, and Justices Barrett and Kavanaugh cast the deciding votes not to overturn it and said, we're not really sure what comes next, so let's not go so far so fast. But I think the clear trend is the court is increasingly embracing this idea of non-discrimination. So if there is a generally applicable program, say a school voucher program, where secular schools are getting benefits, the court is very likely to say religious schools must be on equal footing. And I think this term, the court is very likely to say that extends to schools that are not sort of religious in status, that they're not identifying, with the Catholic Church or other religious groups, but may embrace a religious philosophy or have religious instruction. So there's a lot of movement here. I think the upshot is it's sort of an area where the law swings back and forth. You may think it certainly is a big change from the doctrine of the 1970s. But it's an area where the pendulum of the law sort of swings back and forth. So if you look back further in history, like I don't think it's as big of a change.
Okay, well, it's interesting to see that contrast between the big changes Erwin predicts on abortion and something that may not ultimately historically be that big of a change on religion in general. Let's talk about another doctrine that has really rended the country and been a big focus of attention in the last couple of years. And that has to do with policing, and especially, at least from a legal context or constitutional context, qualified immunity, which of course is a court doctrine. And I'd like to turn to Fred Smith to tell us a little bit about how the court has or will respond to sort of changes in thinking on policing and on qualified immunity for police.
Yeah, sure.
Oh, sorry, I unmuted myself here. I'm here in two places. I'm on my phone and I'm behind here, so sorry about that feedback. Yeah, so the first thing I'll say is read Erwin's book, Presumed Guilty, because it really does do a great job of bringing together how when we're thinking about the relationship between policing and the Supreme Court, there's lots of pieces to the puzzle, right? There's the criminal procedure aspect to the puzzle in terms of the Fourth and Fifth and Sixth Amendments, and he told a story about how over time those protections have been weakened and how the Supreme Court has empowered police to the exclusion of other concerns like reliability and making sure that innocent people aren't convicted, et cetera. But he also talks about, and this goes to your question, questions about how do you hold people accountable when they violate the law, including police. So how do you hold the government officials accountable when they violate the law? And qualified immunity is a place where a lot of the attention as of late has been focused. In terms of where the Supreme Court is on qualified immunity, there've only been 2 summary reversals this year. They both have been with respect to qualified immunity, but they have been instances in which the Court of Appeals denied qualified immunity. And the Supreme Court in both of those cases actually reinstated qualified immunity. And this is consistent with what's been called kind of the trends when it comes to what's been called the shadow docket for some time now, where what we might call stateside petitions, that is petitions to the Supreme Court in which a government official is the one petitioning, have a privileged place on the Supreme Court's docket, especially with respect to the shadow docket. And so the fact that the only 2 cases that involve summary reversals this year are cases in which the court was reinstating qualified immunity certainly does not signal that this is a court that is poised to overturn the doctrine of qualified immunity. Now I'll say that Hobart versus Rhodes is a case last year where Justice Thomas, there's been a couple of moments where he's given some sort of like nuggets of hope to people who are interested in revisiting qualified immunity. He did so a few years ago when he said he raised the possibility that qualified immunity might not be lawful, citing to Will Bode's article on that front. But in Hogarth versus Rhodes, he said something a little bit more nuanced, which is that the Supreme Court should perhaps bifurcate its approach to qualified immunity in cases that involve split-second decisions, as opposed to cases in which there's an opportunity for thoughtful judgment, right? And so in both of the cases, this term where the Supreme Court reinstated qualified immunity, they did involve some of those kind of split-second type of decisions. And so to the extent that we might in the future see some changes with respect to qualified immunity, to the extent that Justice Thomas's opinions in this area give us any tea leaves, it may be there. To the extent that people are interested in broader reforms when it comes to qualified immunity, or for that matter, absolute immunity for prosecutors, or sovereign immunity, or making it easier to sue local governments, because that's also very difficult, or making it easier to achieve injunctions in order to actually stop patterns and practices of violations in policing. It may be that Congress and the state court system, this is where Erwin comes out on it, are the place where we're most likely to see kind of more structural reforms.
It's really fascinating to me, Fred, that, especially as we go through these doctrines, how, the court is an originalist court, is so critical of, for example, the abortion right, which is on originalist grounds, but qualified immunity, of course, has no originalism behind it whatsoever. And there's much less discussion about whether that's a sort of viable long-term doctrine, since the court seems to be reconsidering everything in the context of originalism now.
Yeah, and I have a piece that I wrote called Formalism, Ferguson, and the Future of Qualified Immunity, where I point out that this would appear to be the sort of space where you might see some kind of interest convergence of the sort between people who are interested in more accountability and people who are deeply committed to text and to history. Because as you know, qualified immunity as we know it today, despite the privileged place it has on the Supreme Court's docket, Harlow versus Fitzgerald, which is the case that gave us the contemporary qualified immunity doctrine from in the early 1980s, says that it's a balancing act, that it's attempting to just balance different deterrence concerns, not over-deterring police when they're trying to do their jobs, while also making sure that they're deterring unconstitutional conduct. And it's very explicit about the fact that it's balancing competing principles, which, is not in and of itself necessarily a bad thing, but it is at odds with the kind of strict textualism that we sometimes see in other contexts.
Okay, let's talk about the doctrine on guns. Americans' favorite pastime, I guess. Erwin, can you tell us a little bit about what's going on with guns and where that doctrine of law seems to be heading?
Sure. From 1791, when the Second Amendment was adopted, until June 2008, not one federal, state, or local gun regulation was struck down by the Supreme Court. In the handful of Supreme Court cases about the Second Amendment, it said that the amendment means what it says. It's a right to have guns for the purpose of militia service. But in June 2008, the court decided District of Columbia versus Heller. There, the court struck down a DC ordinance that prohibited ownership or possession of handguns. It was a 5-4 decision. Justice Scalia wrote for the court, and he said there's a right to have guns in the home for the sake of security. Interestingly, since that case 13 years ago, there hasn't been another by the Supreme Court but the scope and meaning of the Second Amendment. But on November 3rd, a month ago, the Supreme Court heard oral arguments in New York Rifle and Pistol Association versus Bruin. And it involves a New York law that's over 100 years old that prohibits having concealed weapons outside the home unless a person has a concealed weapons permit. To get a permit, a person needs to show a need for a concealed weapon. This was challenged. The federal district court upheld the New York law, The Second Circuit upheld the New York law, and the Supreme Court granted review. If you look at the record, the newly appointed justices to the court, they're all staunch advocates of protecting gun rights under the Second Amendment. I think together with Justices Thomas and Alito, there are 5 and likely 6 justices to strike down the New York law. I think the interesting is, what's the court going to do? I think it's going to say there's a right to have guns outside of the home. I think it's going to say there's some right to have concealed weapons. But how can states regulate it? To what extent can states require permits? What will be the criteria for those permits? I think those are all the unanswered questions. But we've got to understand one of the consequences of having such a conservative court. It's a very pro-gun rights court.
It would certainly seem to be fascinating if it becomes more difficult to obtain a license to drive a car than it is to obtain the ability to possess a gun, at least in states that want to regulate them differently.
Except from the perspective of the conservative justices, there's a constitutional right to have a gun, and there's not a constitutional right to drive a car.
Okay, let's talk about another issue, the last doctrine sort of law that I want to talk about. And this is one that is extremely present right now and kind of is getting more and more present as we read about this Omicron variant to COVID. And that is the law that has developed on vaccines, mandatory vaccinations, and restrictions due to COVID concerns. And Fred, can you tell us a little bit about what sort of happened or you see happening in the court with regard to COVID and vaccination requirements?
Sure. So there's really kind of a couple of ways to approach that question, because you have instances in which state governments have issued various vaccine mandates, and that creates one set of questions. And then, of course, you have the OSHA regulations, which would require large businesses to require their employees to get vaccines with certain exceptions. So in terms of the state restrictions, religious liberty has been one of the primary arguments that's been driving the briefing in that area. And those cases, though, haven't met a lot of success, right? So in cases in which there is a religious exemption, those cases have met very little success. But then cases, even in instances where states don't have religious exemptions, such as in Maine, the Supreme Court 6-3 over dissent by Justice Alito, Gorsuch, and Thomas have kind of green-lighted that. And it's not the most nuanced way of putting it, and I'm happy to dig in. But then you have, of course, at the same time, the federal OSHA regulations, and a number of federal courts, including the Fifth Circuit and most recently a district court in Louisiana, which is in the Fifth Circuit, have blocked that. And most recently by way of a nationwide block to that particular regulation. And the Fifth Circuit's ruling, which is the most prominent in this space, it went through the traditional factors that govern whether or not to issue a stay, that is likelihood of success on the merits, whether there is irreparable harm, balancing considering the public interest, et cetera. And on the question of likelihood of success on the merits, they concluded that the plaintiffs were likely to succeed because OSHA is only allowed to engage in these kinds of emergency regulations when they're dealing with something that constitutes a grave danger to employees. And the Fifth Circuit justices were skeptical that COVID-19 is a grave danger, at least within the meaning of the congressional statute that gives OSHA the ability to operate here. They're also skeptical that this was in the public interest. And on that front, they cite it to kind of very broad important constitutional principles like separation of powers and federalism. I think it was somewhat striking for some in reading that in talking about the public interest, that there wasn't a lot of discussion about the pandemic itself, and whether or not this is likely to abate the reach and the harm that COVID-19 is to cause. But all of that said, right, there's now at this point 2 courts blocking the OSHA ruling. There's also a court in a federal district court in Missouri that has blocked a related mandate in the context of Medicare and Medicaid. So to the extent that there's some people who thought that these were, I won't say frivolous, but that there wasn't much there, there at this point are a number of federal judges who are persuaded that COVID-19 doesn't necessarily constitute a grave danger within the meaning of federal law.
Do you think, Fred, that has anything to do with the timing? That is, if these vaccines mandates had been issued in sort of maybe February of 2021, right after the vaccines had come out, that the courts might have been more open to saying, yeah, there's a real emergency going on right now. Whereas, coming after later on, the courts sort of said, hey, we're in the pandemic, we're used to it now for a couple of years, and it's not as much of an emergency.
Yeah, well, the Fifth Circuit, at least I don't know that it was a big part of their reasoning, but atmospherically they certainly noted, right, that this, that given that COVID-19 has been with us as long as it has, can it still be said that it constitutes this kind of a grave danger, and does it suggest perhaps that this isn't an emergency, or at least not anymore? So that may have had an effect. I mean, the Fifth Circuit also noted that that this applies to all employers who employ more than 100 people, and that some people might be more likely to encounter this than others, and so it was concerned that that it was kind of treating all employees alike, where some employees might experience this on the job and then others may not. And so those that seem to be kind of so the concern that you raised may have informed that reasoning.
Okay, well, look, there are obviously a lot of different legal doctrines that we could talk about all day long, but I want to leave it with those and move on to some of the other broader topics sort of going on in the court itself. In particular, I'd like to talk about the justices and kind of what role they're playing since the court shifted so dramatically in terms of its composition in the last few years. And I'd like to turn to David Latt right now. And David, I'd like to ask you about John Roberts. John Roberts, the Chief Justice of the United States, he was sort of set up to be the swing vote. Everyone was talking about how he was going to be the swing vote on this 5-4 court, and he was a conservative, but maybe he'd agree with the liberals on some things, and he certainly did for a period of time. But then Justice Ginsburg passed away, and Justice Coney Barrett came on the court, and he was no longer the swing. There's no swing at all on the court, really, it seems. Is he influential still?
So thanks for having me, Ben. It's great to be on this very distinguished panel. If you'll allow me a point of personal privilege before answering the question,
Always.
I actually graduated from Yale Law School, so your panel is more diverse than you
fantastic.
realize. It's not just
That's
all
great.
HLS
We're
grads.
spreading out, yeah.
But turning to someone who
Harvard
is a
undergrad,
Harvard,
though, right?
yes, that's right, exactly.
Okay, well, there.
But turning to someone who is a Harvard law graduate, namely Chief Justice Roberts, in answer to your question as to whether he's still influential, I guess my answer would be yes, but. I actually feel bad for the Chief Justice as much as you can feel bad for somebody who is one of the most powerful people in the world. If you'll allow me as a former English major to quote Jane Austen's description of her protagonist in Emma, but paraphrased for Justice Roberts, he is someone who's handsome, clever, and rich, with a comfortable home and happy disposition, who seemed to unite some of the best blessings of existence and had lived nearly 67 years in the world with very little to distress or vex him. Well, now he does have something to vex him, which is the loss of the Roberts Court. It is still called the Roberts Court because titularly he is still the Chief Justice. But as you mentioned, with the passing of Justice Ginsburg in September of 2020 and the replacement of her by Justice Barrett, he is no longer the swing vote. So at the end of October term 2019, he was he was really one of the most powerful chief justices in decades. Professor Lee Epstein said that he was the most powerful chief since Charles Evans Hughes in 1937. And why? Because, as you mentioned, Ben, he was both the chief justice, meaning he was the most senior, meaning he would have the assigning power for an opinion whenever he was in the majority, but he was also the swing justice, the controlling vote in those 5-4 cases. And you saw that in OT 2019, he was in the majority 97% of the time. That really is the Roberts Court. But now that Justice Ginsburg has been replaced by Justice Barrett, you have 6 conservatives, counting the chief. But the point is, the conservatives don't need him anymore, especially for some of the most conservative outcomes. Now it's a 6-3 split. And even if he goes with the liberals, conservatives still have control. So, for example, in a lot of the COVID restriction cases that Fred was talking about, as Fred correctly noted, they haven't had much success lately. They had the challenges to those regulations haven't had much success lately, meaning that the regulations have often been suspended in shadow docket cases. But that was not the case back when Justice Ginsburg was on the court. And in fact, there was a high-profile New York case where the regulation was sustained. So it really shows the shift in terms of the replacement of the justices. But why is he still influential? Why did I say yes, but? I think that there are some cases where he might be able to bring along Justice Kavanaugh, who in many ways is temperamentally, I think, similar to him, concerned with institutional considerations, concerned with the reputation of the court, and maybe even sometimes Justice Barrett. It's hard to estimate a justice's performance or predict a justice's performance based on their first term, but in her first term, I don't think she was as aggressively conservative as some people thought. You'll remember in some of her confirmation hearings, people were saying, oh my gosh, she's coming for Obamacare, she's going to strike down the Affordable Care Act. In the end, no, of course they didn't. And I think that those of us who were watching that case realized that wasn't going to happen. But to the extent that she was regarded as some kind of horsewoman of the conservative apocalypse, I think the jury is still out on that. Now, granted, last term, the cases were much less consequential than the ones this term. And I totally agree with Dean Chemerinsky that Dobbs could be really, really just dramatically earth-changing for our jurisprudence and our politics. And the Bruin case about guns will be a major landmark decision. But at least based on last term, sometimes Kavanaugh and Barrett can kind of form with the chief a kind of moderate middle. So he does have some power still, but it's a power based on persuasion, his ability to persuade, cajole, convince Justice Kavanaugh and or Justice Barrett to stay with him. It is no longer the raw power of a vote, and it's not really the power of being chief. So I would say, yes, he still has some influence, but it is greatly diminished. And even if we still call it the Roberts Court because he is chief, he's definitely no longer in control of the outcomes. Oh, that's all I had to say.
I think Ben is frozen.
Oh, okay. Yes, I think he just became the host. Ben, you there?
Does anybody remember what we were going to talk about next? Because we could.
Yeah, I
Sarah
think
was going to talk about
Yeah,
Justice Thomas.
I'm happy
Yes.
to jump in. I was going to talk a little bit about Justice Thomas's legacy. So I guess the first thing I'll say is just from the vantage of what the court is actually like, as opposed to what we read about in terms of the decisions. You might from the outside get the sense that everyone hates each other or that it's constant war, because there is sort of a camp of conservatives and a camp of liberals, and so they're so divided on so many issues. And it's not really, they're also all 9 colleagues who are together for life. And I think this is one of the things that you think anyone who meets Justice Thomas, I think, quickly realizes, which is he's a beloved figure by both the right and the left, because he's not a show-off. And I think he's sort of, one of the most foundational things about him is just his decency. I mean, a recent quote I saw, I think, gets it just right. If you don't want to like Justice Thomas, don't meet Justice Thomas. He is someone who sort of famously will befriend like people who wander in like the hallways of the court going on tours and just get to know them. And so I think that's just sort of the first thing I would say about his legacy, which is civility, just as a member of the court, which is important just in terms of understanding how the court works together as colleagues over time. In terms of his jurisprudence, I mean, I think the most obvious thing is You can either call it bloodthirsty originalism or the courage of your convictions, but he really has been a pioneer of looking at the original meaning of the Constitution, and it can lead to a lot of places where it is not sort of what you would think politically conservative folks would necessarily think. So I think originalism, even when it hurts, I guess, is his philosophy. I think one of his other legacies is a willingness to be very candid in reconsidering his positions. I think a lot of justices historically have had a hard time not just saying that they got something wrong. It's hard to do as a justice, but Justice Thomas has done it in a lot of different areas, including Dormant Commerce Clause, a lot of areas of administrative law. So I guess I want to flag like one area that I think is an overarching contribution he's made to the court, which is just stare decisis, obviously in the news a lot right now, given what's going on in Dobbs. But Justice Thomas is really a long time adherent, or before it was cool, to the view that especially when the court gets constitutional questions wrong, the court should overturn those decisions if they are demonstrably wrong. I think a lot of people see stare decisis just through the prism of abortion, but I actually think Justice Thomas, his foundational views on this come from decisions on race and the country's and the court's history of some pretty awful decisions in that area. And I mean, I think the argument in Dobbs actually is a very good illustration of how you can get to different places on stare decisis, because I thought the most interesting question in the argument was Justice Alito's question for the government. Was Plessy versus Ferguson wrong and something the court should have overturned on day one? Or did you have to wait for intervening social science and other developments? And I find it very hard to stomach the idea. I think this is sort of an illustration of Justice Thomas's general approach that you couldn't at least admit that Plessy would be the kind of decision that was just always shamefully wrong that you would overturn on day one. And so, you know, where you end up in terms of what you think of stare decisis is open to debate, but I think he has been just such a force in terms of developing a different view of stare decisis from what some members of the court had developed, primarily in the abortion context at the outset.
I was asked next in the outline to talk about Justices Barrett and Kavanaugh. And I want to echo something that Mr. Latt said. It's really important not to generalize from small samples. Last year, Justice Barrett came onto the court in November. The court decided 54 cases for the whole term after briefing and oral argument, and Justice Barrett participated in only 44 of them. I think many people want to generalize about Justices Barrett and Kavanaugh from one case, Fulton versus City of Philadelphia, where those two justices didn't go as far as Justices Alito, Thomas, and Gorsuch in wanting to overrule Employment Division versus Smith, something Ms. Harris talked about. But Justice Barrett, even in that case, said she largely agreed with Justice Alito. There was just no reason to have to overrule Employment versus Smith in that case. In doing so, would raise a lot of questions. I think everything we know about Brett Kavanaugh and Amy Coney Barrett, from their writings before the court, from the time as Court of Appeal judges, from their short time on the Supreme Court, is they are going to be very conservative justices. That's why Donald Trump picked them. And if you look at last term of the court, people want to focus on Fulton, but I think most of the major cases came down 6-3. Think of the case that gutted the Voting Rights Act, Brnovich versus Democratic National Committee. Or think of the case that implicitly overruled an important case with regard to juvenile sentencing, Jones versus Mississippi, 6-3. Or a case that used the takings power to limit the ability of states to affect union organizing, Cedar Point Nursery versus Seed, 6-3. And there you've got Kavanaugh and Barrett solidly with the conservatives. And lest there be doubt what I'm saying, go back and listen to yesterday's oral argument. I found one of the most stunning things said was Justice Barrett saying a couple of times, laws that prohibit abortion aren't a burden on women because they could carry the pregnancy to term and then give up the baby for adoption. I think most women would find that very deeply offensive.
Thanks, Erwin. And I apologize, my Wi-Fi cut out for a minute. And so I'm so thrilled that everybody knew what they were supposed to talk about and were able to handle it without me, but I am back. Fred, let's talk about your justice and also Justice Kagan, the liberal wing. What do they do now? They seem to be firmly in the minority and appear to be on the losing side of some, epochal type issues. What's going on? What's their strategy here?
Sure. Well, first, I've been told that when I'm speaking, you just see you don't see my face right now. So if you go to gallery view, perhaps that works. But it's better than the alternative, which is that there's a lot of construction happening in my house right now, and I don't want you to hear that. So that's why I'm doing it this way. But in terms of what do they do? I think that all of the justices understand themselves to be doing their best to interpret the law, and they're going to keep doing that, even if their perspective on what the law is now, increasingly on some of these big issues, increasingly in a distinct minority. And so, that's gonna look like dissent. It's gonna look like continuing to ask hard questions at oral argument, in ways that I think a lot of people paid attention yesterday to the oral argument, including to the questioning by Justice Sotomayor. I think her questioning received a great deal of attention, and so there is still a role in terms of asking questions that make their perspective on the law still relevant, even if they don't always carry the day. Now, of course, all of that said, the role is different when you're one of three as opposed to when you're one of four. Because when you're one of four, you can at least sometimes persuade one of the five, and you only have to persuade one of the other five. And they had a fair amount of success in that. Now they need to persuade two of the six, and that's just going to be a tougher lift. It may be that on some questions, though, that involve questions like textualism, there's some space. So if you think about the Bostock case, which was the Title VII case that said that it violates sex discrimination law in order to, when one discriminates on the basis of sexual orientation or gender identity, that was a pure textualist argument, just based on, well, what does sex mean? Oh, well, if one is discriminating based on, if one wouldn't discriminate against someone who had this biological makeup for doing exactly the same thing, then that's sex discrimination. And so I think thinking about ways to appeal to those methodological commitments in ways that might match up to some more purposive commitments on questions of equality there still may be some there, even if it doesn't appear to be the case with respect to bodily integrity and autonomy.
Okay, and then the last question about the justices themselves that I want to ask about, which I think is the $6 million question, of course, for a lot of folks, is Justice Breyer, who I believe is 83 this year. There's a lot of pressure on him to retire while President Biden is in office, and the Democrats, at least for right now, control the Senate. I think a lot of folks look back to Justice Ginsburg's decision not to retire when President Obama was in office, and Democrats controlled the Senate, and ultimately that led to Justice Coney Barrett taking a seat in the Supreme Court. Sarah, I want to ask both Sarah and David about this. Sarah, what do you think of Justice Breyer, what Justice Breyer might be doing based on sort of the decisions he's issuing and the roles he's playing on the court? And then David, I'd like to ask you about his clerkship hires, because that can also be a good signal of what Justice plans to do. Sarah?
I clearly think Justice Breyer seems to be having a blast, actually. Like, if you listen to that argument, he's super active, he's very engaged, he's interested, even if he might be on the losing side of cases. Like, he almost sort of seems to have extra wind in his sails these days. He's writing books on the side, he's on television, so I have no idea what he's going to do, and it would be sort of presumptuous to guess. All I'm going to say is I think he would probably have like an 8-part multi-factor test to guide his judgment. But he got a lot of plum assignments last term, and he seems to be in good health. So I think the justices just look at the decision very differently. Like, sort of ordinary people look at it sort of as a political thing. Like, wouldn't it be terrible if your replacement is not aligned with that justice? And I just don't think that that is how an individual justice necessarily sees it.
I agree with Sarah, and I think maybe this is much to the chagrin of maybe many Democrats, but I don't think Justice Breyer is seeing his retirement decision in those terms as well. I agree with Sarah. He seems to be loving life right now. He seems to be happier than ever. He's gabbing with Colbert. He's traveling around promoting his book. Like, what could be better? So if I had to give a percentage, and by the way, I'm the king of wrong predictions, but I guess kind of as I feel as a pundit that if you don't get a lot of things wrong, then you're probably not doing the job right. But I will predict that he will retire this year at the end of this term, June, July. But I'm going to say 70-30 chances, meaning that I would be surprised if he doesn't, but not shocked. And I think many observers of the court would be shocked if he doesn't retire. So why do I think that? Well, back in April, on my Substack newsletter, Original Jurisdiction, I predicted he would retire. He would not retire this June based on his hiring of a full complement of law clerks, including one hired as recently as March of this year. And if you look at the last 4 justices to retire, 3 of them actually changed their law clerk hiring and slowed it down, basically, not hiring their full complement of 4 clerks when they had retirement on their minds. Justice Kennedy was the exception, but I think partly that's because Justice Kennedy is a little more sensitive to public perception than other justices and maybe didn't want to give away his plans, but I don't think the other justices really care. And I don't know if Justice Breyer cares that much. So I think we will get a hint from his law clerk hiring. And as of now, please let me know if I'm wrong. You can reach me at davidlatt@substack.com. But as of now, according to my law clerk hiring, which I try to track in real time, Justice Breyer has not hired any clerks for the upcoming term. Now, as a retired justice, he would be entitled to 1, so maybe he'll hire 1, but he has not hired his full complement of clerks. When you look at past years, typically by January or February, he's hired all of them. And as of now, December, it appears that he's hired 0. Now, look, trust me, those are very coveted jobs. He could get 4 clerks in a minute. I mean, heck, I'll go clerk for Justice Breyer, and I'm no spring chicken. And I don't necessarily know if I agree with all of his jurisprudence, but so he can hire clerks like that. But as of now, I'm leaning that he will retire. But where do I get the 30 from? The 30% chance he won't. I think partly what Sarah was saying. I think he believes his points about the court being separate and apart from politics, which has been the stress of his new book. I think he genuinely believes it. I don't think it's just a posture. And I think that if you see the court that way, as a justice, you should time your retirement based on your personal decisions and what's going on in your life and whether you think you can still be of service to the court, as opposed to who controls the White House and who controls the Senate. So I guess what I'm saying is if Justice Breyer does not retire in June or July of this year, yeah, I'll be surprised, but I won't be shocked. And maybe I can kind of say I told you so, since I'm not as definitive on his retiring as many other observers. I think he might very well pull a Justice Ginsburg and stick around until stick around for the foreseeable future.
Okay, great. Okay, so I want to move on from talking about the justices themselves, and I want to stick with you, David, actually, but I want to, at least to start, but I want to talk about something I think that's very important for everybody attending, I think the country overall. I think it's always important to put the court in the context of its times, and these are in many ways tough times. The early 19th century was called the era of good feelings. I've been sort of calling this early part of the 21st century the era of bad feelings. I think there's a perception overall of tremendous division in the country. We've got cultural, social, political divisions. We have a lot of anger out there. We have a global pandemic on top of everything else. We just had a very angry president whose sort of a whole thing was about being an angry person. How closely, David, do you think the court is paying attention to what's sort of being reported and discussed in the media and on social media and in living rooms and at Thanksgiving at this time? How much does that matter to the court?
I would say a lot. And I would say that they are paying close attention, despite often their protestations to the contrary. Look at what I would call their recent charm offensive right ahead of the start of this term in September. You had Justice Breyer going on his book tour talking about how the court is not political and how the justices get along very well. Then on September 11, Justice Barrett gave a speech at the McConnell Center where she was saying that they're not a bunch of partisan hacks. The readings for this CLE session include a piece by Dean Chemerinsky talking about Justice Barrett's speech. And then on September 30, right before the start of the new term in October, Justice Alito gave a speech at Notre Dame defending the court's use of the so-called shadow docket, which had come under public and media criticism. He likes to call it the emergency docket, and he believes there's nothing particularly unusual or untoward about how the court is handling it. So I think it's quite clear that the justices do pay attention to public opinion, and they do want to say that also, kind of what Sarah was saying also, they get along very well, or they always like to say that in interviews. There was a good piece by Joan Biskupik, I can't remember, in the past year, talking about how the justices, especially in the decisions at the end of the term last year, seemed kind of like sniping at each other. And maybe that had to do with the fact that they hadn't been seeing each other in person, having lunch together after their conference, what have you. They seem to be really testy. But now, especially in the new oral argument format, they seem to be extra courteous. They don't interrupt each other as much. Of course, that's because of the format change, which I know we're going to talk about in a sec. But they also seem to say things like, well, I'd like to follow up on what Justice X said. And often Justice X is a justice on the other side of the aisle. So I feel that the justices are really trying to be on their best behavior. And partly it's because of this reporting and this media commentary suggesting that maybe they're not getting along as well as before.
You mentioned the change in questioning protocols. Sarah, let me turn to you for this issue. What can you please remind everyone what the change in questioning protocols was exactly, and sort of what we can glean from that change in protocols? Why, how, what that says about what the court pays attention to and cares about?
Yeah, I mean, I would just pick up on what David said. I think part of it is a really conscious effort now that there is more live streaming of audio, and I think more people are listening, to think hard about what format works for public listeners, but also for the court. I mean, I would just sort of describe the three recent eras in terms of like sports metaphors. So the pre-pandemic, I think someone is echoing though. The pre-pandemic system was sort of more like a free-for-all rugby scrum, where the justices would sort of like pile on questions, and sometimes the arguments would get so fractured that the advocate wouldn't have more than like 5 seconds to talk, and the justices would sometimes talk over each other. It was very fast-paced, so they got out a lot of material, but the pile-ins, I think, got awkward in certain arguments. The court pre-pandemic started to fix that by having, for instance, giving each advocate 2 minutes uninterrupted time before the start of the questioning. And then during the pandemic, it was just a completely different feel. It was more like a goalie drill for soccer, because the justices would ask questions seriatim, starting with the chief in order of seniority. And so you would sort of like block shots by different players who had like very different styles of questioning. Justice Breyer, for instance, having his like 45-second 5-part hypotheticals, Justice Alito often coming in with like a lot of attempted kill shots, like seriatim, Justice Kagan, sort of similar model to that. But it was a little fractured. It was less like a conversation with the court than the old system could be. The new study, I feel like the justices are trying to get the best of both worlds. It's not only back to a free-for-all, but as David was saying, they really are very conscious of letting each other talk a little bit, and they always let Justice Thomas go first. So he's asking questions now every argument, and then the other justices jump in, but are like super polite whenever someone might be talking over them. And I think it's really nice. I mean, it's much more like playing a match of tennis against the court or something, where like you hit the ball back and one of them rushes in to hit it back to you, and it's more of a back and forth feel, and it is more conversational now, both in terms of answers and in terms of the justices, I think, playing off of each other. So, I mean, I think the court's going to keep experimenting with it, but I think the new system is working well, and the arguments are also just longer, so I don't think there's any feeling, whereas sometimes before it felt like some justices just didn't have time to ask questions because someone was dominating. I feel like they've done a good job of making sure everyone's voice is heard.
There was a study not long before this rule change, maybe a couple of years ago, suggesting that the female justices were cut off at much higher frequency, much greater frequency than the male justices. Do you think that had anything to do with this decision, or do you think it really was communicating to the public, especially during the pandemic?
I don't think so, because I think there were some limitations on that study that people had some questions about in terms of which way things went. But I think there was just a general sense that the questioning system was not working out great. So whatever the impetus was, yeah. I think there was probably frustration on all scores that it was maybe not the best questioning system possible for eliciting just both a sense of what the advocate was arguing and then what other justices might think about the case.
So in this new system, what essentially you have is you have the free-for-all, and then at the end, the chief goes seriatim to see if each justice has any more lingering questions. It's sort of like a fail-safe. So as Sarah was saying, I think it is the best of both worlds. You have that spirited conversational bit at the beginning, but then if anyone has questions, they get to pose them at the end when the chief goes one by one to see if anyone has lingering questions. And I think partly because they know they have that time on the back end, they don't need to jump into the rugby scrum. They know that at the end, they will have their chance to ask their specific questions. So I'm a big fan. I actually endorsed a system like this in a story for Above the Law during the pandemic, saying when they come back, they should do something like this. And so I'm glad they've done it.
Obviously, we know where they got it from, right? We know where that idea derived from. Erwin, are the justices more political than they used to be?
No, though I think we've got to be very careful about using the word political in connection with the Supreme Court. In one sense, they're not now and never have been political. None of us can go lobby the justices in the way we're quite able to lobby a city council member, a state legislator, or a member of Congress. So far as we know, justices don't trade votes with one another in the way we would accept in a legislature. But if what we mean by political is ideological, the justices have always been ideological. Marbury versus Madison wouldn't have come down the way that it did, except for John Marshall's ideology. From the 1890s to the 1936, the Supreme Court struck down over 200 federal, state, and local laws protecting workers and consumers because of the ideology of the justices. Now, obviously, an ideological continuum, some justices are more ideologically defined, more staunch in their political beliefs than others. I think the one thing that's unique now is that the 6 conservative justices were all appointed by Republican presidents, and the 3 liberal justices were all appointed by Democratic presidents. I think that heightens the sense of a politicized court. Until relatively recently, we had liberal justices appointed by Republican presidents. Think of John Paul Stevens or David Souter. And we had conservative justices appointed by Democratic presidents. Think of Byron White, who dissented in Roe versus Wade, Miranda versus Arizona, or before that, Felix Frankfurter. But I think constitutional law always been largely about the ideology of the justices, and it always will be.
In a way, I have to say, I find that almost reassuring that as the court changes so dramatically, that's still part of the same sort of thing that we've been doing now for, what, 230 years or so.
If
Maybe.
you like the ideology of the justices, then it's something to applaud. And if you're politically conservative, this is a time to be jubilant about the court. And if you're politically liberal, then I think it's a time to feel a good deal of despair about the court and what it's going to be. Amy Coney Barrett was 48 years old when she was sworn in last October 26th. If she stays on the court until she's 87, the age Justice Ginsburg died, she'll be a justice to the year 2059.
Well, anyway, it's almost hard to imagine what the world will be like in 40 years like that, right? Almost 2060. Okay, well, that's a great lead in to our next question, which will go to Fred, which is what's happening with term limits and court packing and adding justices or removing justices, some of the things we've heard folks talking about in the political sphere over the last year or several.
Yeah, so there is a bill that was proposed by Senator Markey and Congressperson Mondaire Jones and Hank Johnson and others back in the spring that would have added additional Supreme Court justices. That didn't get a hearing. And Speaker of the House Pelosi said that part of it was that she wanted to see what happened with the president's commission. Well, the president's commission doesn't seem to have a lot of appetite to say much about term limits either. And they seem to, the tone of it is that they're a little bit skeptical to say the least, of adding additional justices. So I don't think that's going to create any additional kind of political capital or room with respect to term limits or with respect to adding additional justices. Going back to the abortion case, though, depending on what they say, and certainly if they, as some justices seem prepared to, if they really go for broke and overturn Roe versus Wade and conclude that either that there is no right to privacy or that the right to privacy is not so extensive as to prohibit laws that require and compel women to give birth, I think you might see some more energy around either term limits or around adding additional justices, or around some of the other ideas out there, like kind of rotating one's time, like as a Supreme Court justice as we understand it, right? So you could imagine a system in which appellate court judges go through some kind of regular rotation where they are at the Supreme Court, which might result in a little bit less deification almost of that particular body, and perhaps even a little bit more modesty with respect to the decisions that they make. So there are ideas that are out there. They haven't gotten a whole lot of success in Washington, but I think that could change depending on what happens with the court's handling of Roe.
So that's fascinating. For example, one of the proposals is an 18-year term for justices that would allow essentially each president to appoint 2 justices. It's kind of moving somewhere, but not really fast. But you think that if the court directly overturns Roe, that may push the idea of term limits or some other changes to the court structure a little bit more aggressively?
Yes, I do.
Yeah. David, you're nodding. You think so too, it sounds like.
Yeah, I agree. I think the court has been in its current configuration going back to whatever, the 19th century or something. But, it's not constitutionally mandated that we have 9 justices. And I personally am in favor of term limits. I like this 18-year proposal that a lot of people are talking about. So I think we might see it, especially if Roe is overturned, which I think would be very big, and maybe, as Dean Chemerinsky was saying, we don't even realize necessarily how big it will be. But I agree, based on oral argument yesterday, I was kind of surprised because I was expecting the justices to ask tough questions of both sides, and they didn't really. The tough questions were almost all for the 2 lawyers on the side of the clinics. And I almost viewed that as the sort of swing justices like Roberts, Kavanaugh, Barrett, kind of trying to get the public ready for what they're going to do. Because if they kind of ask tough questions at both sides, everyone's being like, oh gosh, we're such suspense. But they have already telegraphed through the argument. Now, look, I know we had the ACA case, and it's dangerous to read the tea leaves based on argument. But again, remember, this is a 6-3 court. They don't need 6, they don't need 6 votes.
Yeah. Okay. The last thing I want to talk about before going to questions, if anyone has any, is the so-called shadow docket, national injunctions. The shadow docket, even the term is sort of implies some sort of evil or manipulation. Sarah, what do you think about the shadow docket? Do you think it's as problematic as people seem to think? Why are we talking about it more than we used to?
So why are we talking about it more? I think, I do think the shadow docket can make people think it's nefarious. So there's a couple things going on. One is the court has always had a feature of its docket for emergency action. That is particularly true of death penalty cases, always a feature of the docket. And there's always been a category of stays where, say, there are urgent actions, like a state law about to go into effect that you think is unconstitutional. You might go to the Supreme Court and see if the court will either allow it to go into effect because a federal appellate court has enjoined it, or do the opposite. Why are we talking about it now? I think it in part is because of the last administration, the rise of so many more. I really do think it's driven by a lot of administrative law developments. And it's not just the rise of national injunctions, in which you see a lot of district courts enjoining a nationwide policy. But even partial injunctions of nationwide policies and administrative law tend to get to the Supreme Court now because there are a lot of there are just a lot of nationwide rules of massive importance that if they don't work in like one piece of the country, it's very hard to see how they would operate. It will be it'll sort of be asymmetric and weird. I mean, for instance, think about the vaccine mandate if it were enjoined in like the Seventh Circuit, but not the rest of the country. It's a weird situation where there's no one else to deal with a lot of these situations. There are inherently fast-moving questions about it, and it's very hard to have a sort of full briefing and argument schedule, which usually takes like upward of 4 months to do. So, I mean, there's just a lot of nationwide policies these days, like going up to the Supreme Court that way. And then COVID restrictions, of course, became like the additional pile-on for this feature of the docket. How you feel about the emergency docket in large part depends, and I think something Fred was talking about, which is how you feel about what the standards should be for injunctive relief at this stage. And I think a lot of the criticisms of this docket are people who think very strongly that there should be more briefing, maybe even oral argument before the court is deciding on these questions. And I think that's just a hard balance, because realistically, if you are thinking about policies that are about to go into effect and could affect large numbers of people, it is pretty hard to actually make that happen in every single case on the emergency docket. So in that sense, I think the criticism, it's hard to envision a different system that would work better. I'll just leave you with one thought, which is, honestly, it doesn't matter what I think, but what the court seems to think is that they are being receptive, I think, to some of these criticisms. And how you know that is 2 cases that got added to the merits docket for like virtually immediate briefing and argument. One was a case called Ramirez, which is a death penalty case that was just argued with respect to whether the prisoner could have his pastor laying hands on him in the execution chamber. The court took that off the emergency docket, granted it, had full merits briefing and argument like within about a month. And then, of course, the second is the Texas abortion law, which is on a similar calendar. Whether the court will keep doing that with things from the emergency docket is an open question. It was obviously a huge burden on the parties, and I think on the court, to accelerate things that much, but they obviously thought it was important enough to try.
Okay, so that's our hour, essentially. Those are the questions that our terrific panel was able to discuss in the time we had. I want to thank Erwin, Fred, David, and Sarah for the really great insights. For those of you who are awaiting CLE credit, they will be emailed to you after the program. For those who can stick around, and I know Erwin at least has something to do, there may be 1 or 2 questions in the comments that I'll be happy to pose to you, and hopefully you can give your thoughts. And of course, anyone who has to head out, we thank you for joining us. One question, and actually I'll go to you, Sarah, is why do you think Justice Thomas is talking so much or so much more? Is it because of his place as the senior essentially the senior justice behind the chief? Or is it because of the new argument format? Or is it because conservatives are now so much more in the majority that he's more excited about the cases? What do you think's going on?
So I think Justice Thomas has always been excited about the cases, and you can probably tell that from the fact that he writes so much. He's always written a lot.
And anyone who doesn't know Justice Thomas off the bench, he is loquacious and outgoing and unbelievably friendly.
I think the answer is something he's gone on record about, which is I don't think he was a huge fan of the rugby scrum format. He is someone who's very much wanting to hear what the advocate actually has to say, and I think you see that even in his questioning. He's very, very polite as a questioner, and even if someone is sort of evading his question, he finds ways of asking the question again without making the advocate feel bad. It's, I guess, how I would put it.
Okay, well, that's a very good reason. That seems to make a lot of sense. Let's see. There was another question about well, I guess this would go to Sarah, to you again, although of course anyone else should feel comfortable to join in. There's a question about religious rights. In one of Justice Ginsburg's final opinions, she sort of suggested that religious rights would become privileged against all other constitutional and statutory rights and become sort of superior rights. Do you think that that is likely to occur? as the court continues to go forward? And do you think that would be a far-reaching change, if so?
I guess that's not really how I see where the court's jurisprudence is going. I mean, I think you could look at it actually sort of the other way of looking at it is a course correction, where you can certainly see the cases in the 1960s and 70s that I've sort of talked about earlier that the court is chipping away at, as in some ways putting religion on like a sort of disfavored status and endorsing, for instance, exclusion of religious groups from various benefits programs and prohibiting various forms of indirect or direct aid to religious groups, even if it is for sort of secular type projects or whatever. So I don't think it's so much putting religious groups on favored status. I think it's more the rule that the court at least is announcing is certainly one of non-discrimination. And I think that is sort of the focus of the jurisprudential efforts. Now, of course, I think it really depends on where you sit, because I think from Justice Ginsburg's jurisprudential vantage, a lot of this is sort of I think she saw it more as a stark divide between, say, for instance, LGBT rights on the one hand and religious groups on the other. And I guess it just depends on how you feel about the framing. I'm not sure that's the right way of framing some of those issues.
Sure. And then the final question, and I will open this up to anyone who has any thoughts. If, as Erwin, who did have to leave the panel for another commitment, if the Supreme Court does overturn Roe and Casey and the abortion doctrine as it's existed since the 70s or the 90s, depending on whether you're looking at Roe or Casey, but if the court does that, do you think the abortion doctrine and the right is sort of sui generis, it's its own thing, or do you think that changes in the law regarding abortion are going to have a big impact on other areas of law, like privacy rights to the extent they exist, or liberty rights to the extent they exist, or personal autonomy rights within, I mean, in some ways within substantive due process in general, which of course underpinned same-sex marriage rights. Do you think that this is the beginning of an even bigger change in what our jurisprudence is going to look like regarding individual liberty, or not?
So I have a quick thought on that. I think you're right, or the way you put it as one of the options is right. I think abortion is somewhat sui generis. It was very interesting, the Dobbs argument. Scott Stewart, the Solicitor General for Mississippi, when asked about other cases related to substantive due process or privacy, basically essentially eschewed any desire to get Obergefell overruled or Lawrence overruled or any of the cases about educating your children overruled. And so, as some of the conservative justices I think have complained, but I think there's some truth to it, abortion, there's kind of almost like special rules for abortion. Like I think that it is going to be, I don't think there's going to be much ideological spillover. But what I will say about abortion and other rights is watch the Whole Women's Health v. Jackson case, which is the case about SB 8, the very cleverly designed Texas law where private plaintiffs can sue over abortions. Because that case, deputizing private plaintiffs to avoid judicial review because there are no state defendants to sue pre-enforcement, that case could have implications for other rights, which is why I think the court, even though it's conservative, might actually rule in favor of the clinics there because it's trying to protect its own turf and the power of judicial review. So anyway, I would say watch Whole Women's Health to see what might happen to some other rights.
Yeah, well, also, I mean, it depends, of course, on what the court says, right? So some of the questions yesterday during oral argument really did go to the heart of the right to privacy. There, some of the questioning centered a lot on the fact that this isn't an enumerated right? And so, I mean, the Ninth Amendment is very much the underpinning of a lot of right to privacy jurisprudence. But in some of the questioning yesterday, it seemed that if something isn't expressly enumerated, then it's in and of itself kind of on different constitutional footing than rights that are enumerated. And so this broader right to privacy then I think is potentially at stake. And if they were to actually undermine substantive due process this is a general matter, and a right to autonomy and a right to privacy is a general matter, the very same right that says that the government can't force Americans to give birth is the same right that says that the government can't force someone to have an abortion. And so will we see immediately kind of a sea change in terms of the law, with Obergefell and contraception laws. Maybe not immediately, but I think one should be careful about assuming we'll never live in a world again where a state wants to ban contraception, or that we'll never live in a world again where the state wants to sterilize people. And so making sure that I hope that they're thoughtful as they write these opinions, if they uphold this Mississippi law, that they're thoughtful about making sure that people's basic integrity and autonomy is respected in the years ahead.
Yeah, we in California perhaps sometimes don't think about things like banning contraception, let alone banning abortion. But you're in Georgia, and there are other folks from all over the country on this panel in places where those may really be considerations, that we may be in some way returning to a sort of pre-1960s worldview in some areas of personal liberty, at least to the extent those areas of personal liberty are constitutionalized.
Yeah, I mean, I guess like on that sort of front, like there has been a lot of doom and gloom on this panel on that front. And I do think like the parade of horribles aspect of this is sort of a little premature in terms of we have no idea what's going to happen in Dobbs. And I'm not sure that the parade of horribles necessarily leads to sort of like a pre-1960s worldview per se. I think that was sort of the point of some of Justice Kavanaugh's questions of Scott.
Well, we will find out before the end of June. And if I can convince them, maybe we'll get our panelists back at some point in time, maybe next year or something like that. And we can kind of look back and see what exactly happened during this term that seems quite momentous. Thank you so much to all of you for attending. Thank you to our attendees, and my personal appreciation to everyone. Happy holidays.
Thanks so much, everyone.
Thank you.
Thanks, everyone.